and 21st of December 2025, Malaysian police successfully dismantled an international drug trafficking syndicate in Penang, seizing approximately 1.2 tons of drugs. According to Datuk Hussein Omar Khan, Director of the Bukit Aman Narcotics Criminal Investigation Department, this amount of drugs could potentially affect 6 million addicts. This incident highlights the serious social impact of drug trafficking and the important role of criminal law in protecting public safety. As with any other criminal charge, the accused in a drug trafficking case is also entitled to invoke any applicable defences, either the statutory or the common law ones, to rebut the prosecution's case. The defence of duress stands as one of the most contentious and complex legal justifications raised in criminal cases. To gain a better insight, it is recommended that one complement the study on the defence of duress in drug trafficking cases with a statistical data analysis. There are 4 objectives to be discovered from this study. The first one is to study the defence of duress under the Malaysian Penal Code Act 574. The second one, to examine the application of duress as a defence in Malaysian drug trafficking cases through statistical data analysis. The third one, to analyse the success rate of duress as a defence in Malaysian drug trafficking cases and the legal ground behind the decision of this case. And the last one is to propose the recommendations based on the observations and inferences from the case analysis.
Section 94 of the Malaysian Penal Code provides duress as a defence for all criminal offences except murder. Under this section, a person is not liable if an act is committed due to a threat of imminent death and the accused reasonably believes that there is no other safe means of escape. Several conditions must be satisfied for the defence to be valid. First, the threat must be involved in death rather than mere injury or harm. Second, the threat must be immediate, meaning future threats are not sufficient. Third, the threat must be directed at the accused personally, not at family members or others. And fourth, the accused must not have voluntarily placed themselves in a dangerous situation that lead to the threat. The Malaysian courts apply these requirements strictly. The defence of duress is considered an accuse, not a justification, which means it only relieves the accused of criminal liability if coercion is proven. Courts also require that the threat be extreme, persistent and real, making the defence difficult to establish in drug trafficking cases.
The analysis of duress in Malaysian drug trafficking cases is based on data from 3 main sources. The Malaysian Law Journal reported 8 cases, the Malaysian Law Journal Unreported reported 17 cases, and all Malaysian electronic judgments contain only 2 cases. In total, 27 cases were analysed. Cases reported in Malaysian Law Journal often establish important legal principles or precedents, while unreported cases in Malaysian Law Journal Unreported focus on factual outcomes and practical applications of duress. Moreover, the limited number of all Malaysian electronic journal cases is due to its focus on digital access to selected judgments. Regarding the court levels, most duress claims were heard at Court of Appeal, with 21 cases educated at this level. The High Court heard 5 cases and the Supreme Court heard only 1 case. Historically, the Session Court dealt with drug trafficking offences that can be specifically seen in the case of Muhammad Yusof bin Haji Ahmad versus Public Prosecutor in 1983. But capital offences such as Section 39B are now tried in High Court due to mandatory severe penalty, which is death penalties. This distribution shows that duress claims are often considered at appellant levels, as accused person seeks to challenge conviction or sentences.
Moving on, the frequency of duress claim in Malaysia drug trafficking cases increased over time. Between 1983 and 1992, only 2 cases invoked duress. Between 1993 and 2003, there were also 2 cases. From 2004 to 2014, this number rose into double to 4 cases. However, between 2015 and 2025, there was a significant jump to 19 cases, indicating increased recognitions and uses of the defense in recent years. Furthermore, the types of threat alleged by accused persons fall into 3 categories. 6 cases involve threat directly at the accused personally. while 8 cases involve threats against family members, and finally 13 cases involve threats against both accused and their family. Based on our findings, Malaysia courts generally do not accept threats against family members as a valid for duress. For example, in Koh Keng Guan against public prosecutor, the court held that threat against the accused family did not constitute duress as there was no immediate personal danger. Similarly, in the Loh Fung Ngan against public prosecutor, threats using photos of family members were considered vague and insufficient. Thus, court required that the threat must be immediate, extreme, and directed at the accused personally.
The success rate of duress as a defense in Malaysian drug trafficking cases is extremely low. Out of 27 cases analysed, only one case, which is public prosecutor against ASIAH was partially successful, which resulting in a success rate of approximately 3.7% and failure rate of 96.3% out of 27 cases. In this only successful case, the accused was acquitted of the trafficking charge but was still convicted of possession. This is because the court found that the threat was imminent, extreme and persistent, lasting for about a week and causing reasonable apprehension of death in the accused's mind. In contrast, majority duress defences failed in 26 cases because they did not satisfy the strict legal requirements of Section 94. Courts frequently rejected duress where the threat was not immediate or the threatener is not present to carry it out instantly. This can be seen in Christopher Uchenna Ifogo against public prosecutor, where the court held the threat lacked these elements because the accused was no longer under the threatener's watch and could have sought help from Malaysian authorities. Another reason for rejecting duress as a defense was a voluntary exposure to the risk, which is often described as a predicament of accused own making. The findings indicate that courts are unwilling to allow duress defenses where the accused knowingly placed himself in a situation that led to the threat. In Reza Malik Zadeh Sahabali against public prosecutor, where the court held that the accused voluntarily accepted the job for financial gain and therefore could not rely on duress. Another significant factor contributing to the failure of the defense was the accused's inability to demonstrate there was no safe avenue to escape. The analysis indicates that courts consistently dismiss duress defences where the accused could have sought help or escape but failed to do so. For example, in the case of Lim Then Kiang against public prosecutor and another appeals, the defence was rejected as frivolous since the accused could have escaped or sought help at KLIA 2 but chose not to. Subsequently, threats to kill close family members rather than accused personally are generally insufficient, which the courts require the threat of instant death to be directed at the accused himself. This can be seen in the case of Koh Keng Guan against public prosecutor, where the court found no evidence that the accused faced a personal threat of instant death, despite his claims of protecting his family.
First, it is important to clarify the legal standards. Court could adopt a more flexible interpretations of threats, especially when they are indirect or involve family members. A clearer definition of what counts as an imminent threat could make the applications of duress more fair, particularly for those forced into trafficking under extreme coercion. Second, there is a need for educational outreach. This is because many accused persons may not know about their rights or the ability of the duress defense. Thus, public legal education campaign can raise awareness and ensure that accused persons do not plead guilty because they are unaware of legal protection. Third, judicial discretion should be improved and judges should be allowed to consider the accused's mental and emotional state when evaluating duress claims. A case-by-case approach allows courts to assess the real circumstances rather than strictly apply rigid legal rules. In summary, clarifying the law, increasing awareness, and improving judicial discretion can make the defense of duress more equitable and effective, yet still protecting public safety.
To conclude, defense of duress in Malaysian drug trafficking cases is rarely successful. Although Section 94 of the Penal Code allows a person to rely on duress, the court sets strict conditions, specifically, the threat must be imminent, extreme, and unavoidable, and the accused must have no safe means to escape. As a result, most duress claims fail. In fact, out of 27 cases analysed, only one case was partially successful. Furthermore, the courts generally do not accept threats made to family members or distant threats as a valid duress. In addition, if the accused voluntarily expose themselves to the risk or carry out deliberate acts, the defence is considered rejected. This strict approach reflects the court's focus on deterrence and public safety. Therefore, while duress remains theoretically available, it is accepted only in very rare situations where a person faces extreme threats and has no way to escape. By keeping the rules strict, the law protects only those who are genuinely forced under extreme threats, while clearly showing Malaysia's strong stance against drug trafficking.